All right. So this is part two of chapter six, reviewing the briefs that are due this week. State versus Smith is our next case. In State versus Smith, the court is looking at public safety issues. And the question is whether or not do we have a public safety exception to the Miranda rule? And in Smith, um, you have law enforcement that is called out because an individual is assaulted, and they know that in talking to the victim that the suspect has used a gun. There was a second suspect that also was in possession of a gun. And so when the cousin or the primary suspect comes back to the crime scene and confronts officers, they do not Mirandize him. They know who he is. They have information that he's violent. They can see by the victim's physical injuries that this defendant is violent, and so they start demanding to know where the guns are, and they do this without Miranda. And so the question becomes whether or not there's a public safety exception. So the court uses or talks about this old case, New York versus Qualls, and they're using that case. They're talking about the facts in that case and comparing it to how it would apply to Miranda. And so what the court does determine, one, is that there is a public safety exception. The other thing that you should observe is that this exception, the court views it from an objective standard, meaning based on the information that the officer has, is the demand for information reasonable under the circumstances? And so it's not a Monday morning quarterbacking point of view. In other words, they're not going to say, well, here's what actually happened, and the officer should have Mirandized based on the actual events. It's based on the information that the officer has. So if the officer has information that later on we find out is incorrect, um, the standard is what information did the officer have at the time that they decided to use the public safety exception. And it's an objective standard. It would, if you look at the totality of the circumstances, is the officer's request, its primary focus is the protection of the officer or the protection of the public. And so that's how the court looks at it. So they will take the information that the officer had at the time and determine whether it was reasonable for the officer to use the public safety exception. There's no requirement for an announcement. It's a decision that the officer makes on scene, and then it would be challenged later on in court by the attorneys if the defense attorney, felt that the officer was in error and their client was entitled to Miranda warnings. Okay, so the next case that we have is Maryland versus, is it Chptr? So you have a suspect that's incarcerated on a sexual assault charge in 2003. You have officers that interview him, and he invokes his Miranda rights. And then, so the general rule is that if you invoke your Miranda rights, then the officers cannot go back and talk to you. You can invite the officer back if you change your mind, but the officers cannot return on their own and ask you to reconsider. That would be a violation of the Miranda rule. Well, in this case, in 2003, the officers approach him. He asserts his Miranda rights. The officers walk away, but the officers go back and interview him 2 years later. And so the question becomes, did the officers violate that general rule that officers can't go back? Oh, sorry, I didn't move that. That officers can't go back and interview someone. So when you read this case, there's a point in time when the court talks about the purpose of not allowing officers to go back. And they focus in on the idea that if you're in custody and officers impose or ask you questions and you decide to assert Miranda, you are still in custody. You're still in that coercive environment. So for officers to come back, um, the court views it as a form of intimidation where you're not free to talk to other people, you're not free to get advice from others, you are still locked up, and officers are coming back a second time. In this case, this defendant was confronted by law enforcement. They were released. They had 2 years to reflect on whether they wanted to talk to officers. They had the opportunity to talk to others. They had the opportunity to talk to family, to talk to an attorney. And so the court says in this case that going back and talking to the individual was not coercive because of the length of time, because he was free. At one point, he's let go. He's out of custody, and so they compare the two. So the key in looking at this case is comparing why the court restricts or denies an officer a chance to go back and ask the person to reflect on the initial decision not to talk to law enforcement, and how in this case, because the factors are different, they say it's not a violation. So it gives you a clearer picture of the purpose of and how the court views the role of Miranda and how they believe that Miranda rights protect an individual from being coerced into making statements that they otherwise would not make. Okay, so the next case is the Tompkins case, and in this case, let me just get in this case, the defendant's arrested for murder, and so they provide him his Miranda rights. They give him a form and ask him to sign the form acknowledging his Miranda rights. The form is not required. Some departments will use a form, or they may have a policy that whenever possible to have the defendant sign a form. That's just a way to protect the officers to ensure that if the defendant later on comes back and says, well, I was never provided my Miranda rights, they have some type of proof, excuse me, that they were actually given their Miranda rights. But oftentimes now, in most cases, the officers should be recording any kind of conversation they have with an individual. All right, so in this case, you have a defendant that refuses to sign, and the officers continue to ask questions. And they ask questions for almost 3 hours. I think it's 2 hours and 45 minutes around there, that they're continually asking questions, and the defendant says nothing. So the issue is the individual's silence a way of invoking his Miranda rights? So should the officers interpret his silence to be an invocation? In other words, is he saying, I do not want to talk to you, I want to remain silent? Or is he saying, I want an attorney by his actions of simply remaining silent? So the general rule is that the court puts the burden on the individual to be very clear that they wish to remain silent and not talk to officers, or that the individual wishes to have an attorney present before there's any questioning. And that rule has not changed. And this case says that mere silence is not enough. You have to openly assert whether or not you want to remain silent, or whether you want an attorney, or when you read this case, pay attention to the court's view on putting demands on officers. So what the court's trying to do is not create an environment where the officers are in a place where they have no idea what to do. Because people aren't always really clear about their intentions. And so if the court puts the burden on the officer, then the officers are going to constantly be second guessing statements made by a defendant, and only to find out later in court that a judge has ruled that they made an error, and it just creates a messy situation. So the court, in order to keep things clear, clean, to protect the individual and protect the law enforcement and protect, their ability to investigate crime and keep us safe, they make a very clear rule. If you want to invoke your rights, you have the burden of doing so. Merely staying silent is not enough. All right, so you have Davis versus United States. And in Davis, in Davis, so defendant's given his Miranda rights orally and in writing, and the defendant is a murder suspect, and in this case, this is a good example of somebody who's not being very clear. He says, "Well, maybe I need a lawyer. Maybe I should get a lawyer." And so the officers aren't really clear on what they should do, so they just ignore him and they continue talking. And the court again follows the same rule, same logic. You have to be clear. Saying that you might want one, you may want one is not enough. And the officers did not violate Miranda when they continued to ask him questions after he made those statements. So the rule doesn't change. Statements like, well, maybe I need a lawyer, or maybe I get a lawyer. Oh, it looks like I'm really in trouble. I probably should get an attorney, is not enough. You have to be very clear that you want a lawyer. All right. In Missouri versus Serbert, however you pronounce it, you have a suspect and her sons are conspired to burn down their home to conceal circumstances where there's a death inside the home. One of the children die, and so they decide to burn down the house. And in doing so, another child is killed. This is probably one of the most difficult situations for an officer is when somebody starts to talk. They may start out in the investigative mode, which does not require Miranda, and then all of a sudden the person they're talking to starts to give them information. And so it moves from that investigative stage to the interrogative stage where, based on the statements of the individual, the officer says, holy golly gee, this guy is our suspect. And now the question becomes, when do I stop and provide Miranda rights? And this officer did two things wrong. One is they continued to let the individual speak, and they should have stopped him and provided Miranda rights. But this officer let him talk for a period of time, and then after the person made several incriminating statements, stopped, provided Miranda, gave him about a 20-minute break, and then went back and continued asking questions, and then incorporated the earlier statements into the interview after Miranda was given. And so the court says, no, if once you invoke Miranda, you have to give the individual time to reflect, especially if they've already given incriminating statements. And so these are really difficult situations. It's difficult for the officer to know when to stop and provide Miranda. It's difficult for the officer to determine how long they need to wait to make sure that they're not in any way coercing the individual, or the fact that this person has already made incriminating statements will unduly influence the person to continue talking. And so what this court says, that clearly in this case, the officer did not give the person enough time to reflect and understand, and the officer should have stopped talking to the individual. All right, and then the last case is Wilson. And Wilson is, Wilson's pretty straightforward. You have another confidential informant in jail. And in this case, there are no coercive statements. He simply tells the guy, hey, you need to get a better story. And so then the guy comes back and gives a full confession. That's not intimidating. That's not coercive. And the court says that's a perfectly appropriate statement to make. And therefore, unlike the first case where somebody says, I'll protect you if you tell me the truth, this person made no promises. They just criticized his original statements. And in this case, the court says that that's not coercive or intimidating, and therefore the statements come in. It's not a Miranda violation. Okay, I do not need you to respond to this video. Simply do your briefs. That's the only thing that you have to turn in. So if you have any questions, shoot me an email, and good luck.